Okay, I'm addressing my opponent's claim today that at what point are drinking and driving accidents to be blamed on the restaurant or bar that the person was drinking at. The law is very open to interpretation and has gray areas. My speaker continued to say that there needs to be clear laws on businesses' liability for drinking and driving. First of all, this claim is 3 sentences long, and the only one that is actually a claim of fact is the second sentence, which is that the law is very open to interpretation and has gray areas. The sentence was very vague if it wasn't connected to the other supporting sentences. But to address that sentence specifically, according to Christopher L. Eisgruber, who is the provost of Princeton University, who has also clerked for Justice John Paul Stevens of the United States Supreme Court, says that judges have a duty to interpret and apply the law. So thus, laws are always meant to be interpreted, and this is basically the basis of the judicial system. So I feel more that my opponent is trying to say that, I'm trying to declare that California laws regarding alcohol distributors' liability of intoxicated people are altogether unclear. So he doesn't actually give us specified secondary claims, but only offers information. The information he does provide is the 3 subsections of the California Business and Professions Code, Section 25602, the 3 court cases disputing the degree of liability of servers for intoxicated people, and then also his personal experience and listing 3 conditions in which a person's level of intoxication can be skewed or concealed. So I'm going to address these 3 different things of information to show that the law actually is clear. So the first one, that he lists the California Business and Professions Code, Section 25602. I was saying that they clearly define the law regarding liability of those intoxicated. For its subsections A, it says that every person who sells, furnishes, gives, or causes to be sold, furnished, or given away any alcoholic beverage to any habitual or common drunkard or to any obviously intoxicated person is guilty of a misdemeanor. The second one, it states that no person who sells or furnishes alcohol is civilly liable to any injured person or the estate of such person for injuries inflicted on the person as a result of intoxication by the consumer of such alcoholic beverages. Basically saying that that whoever distributed, whether it be a bar, a bartender, or a restaurant, they are not civilly liable to that injured person or the estate or any third parties that they inflict harm on. The second one does say that the legislature hereby declares that this section shall be interpreted so that the holdings in cases such as the 3, I don't have them listed, but the ones that he used also for his second piece of information, that the holdings in these cases be abrogated, which means to repeal or do away with, which is defined by OxfordDictionaries.com. So in favor of judicial interpretation, finding that the consumption of alcohol beverages rather than the serving of alcoholic beverages as the proximate cause of injuries inflicted upon another by an intoxicated person. So the law clearly states that, and that the second point that my opponent suggested that these 3 cases kind of conflicted with that. It's stated in the law that these 3 cases should be repealed and that you shouldn't look to that. And it shows that any contradiction that these laws have with these previous cases, it addresses that, and it says that you need to, take those out and follow this law stated specifically in that code. Also, for those 3 cases that he suggests or that he offered, there's plenty of other cases that have followed that law and that do not contradict that, such as Biles v. Richter, Andre v. Ingram, Cole v. Rush, and that these aren't really strong points to say that this law is confusing and unclear, because numerous or all other cases do support the law that it states. His last claim about the 3 instances that a bartender may be unaware of a person's intoxication, he really they seem reasonable and they're from personal experience, and they seem, I don't see anything wrong with them, but they don't support any secondary claim. He doesn't tie them into his argument at all. Also, he says that if I continue to sell you alcohol and you leave the bar, we are now responsible for any accidents or injuries that you cause, which is false as stated in the code that I previously mentioned. But also, unlike a number of other states, California doesn't require its retailers to participate in responsible beverage service training. So this responsible beverage service training, as according to Alcohol Beverage Control Enforcement, the legal research report, says that service training programs have two goals: to establish policies and procedures in retail alcohol outlets for preventing alcohol sales and service to minors and intoxicated persons. Two, to train managers and servers or clerks to implement those policies and procedures effectively. So if there's any contradiction or unclear, like it's not unclear, this confusion may be, and like the gray areas may be due to lack of training, but not the law, because the law clearly states all these points. Lastly, my opponent concludes his argument saying that my point is there needs to be a more defined area for bartenders, servers, and owners about what obvious intoxication is. That they need to have a percentage of blood alcohol level that defines the intoxication level, and also that these situations can shut down business and get employees fired, so the law needs to go further into details on what obvious intoxication is. This makes me think that my opponent's argument was more about like not being clear on what obvious intoxication is and not on the actual law. But when talking about the actual law, California clearly states it out in its codes, and he does not properly back that, there are gray areas and that it is unclear.
All right, well, I thought you did a very good job taking the claim that you thought was somewhat ambiguous, focusing in on where you found there to be a claim of fact, trying to isolate what the supporting issues are, even if they are not stated as objectively as they might be in a more straightforward claim. You did exactly what you need to do. Say, it appears that the inference that the advocate is making is this, and here's the response to that inference. And I thought that you did that very well on all of those individual points, especially on the sections where you're talking about the code, because in essence, you're saying the code itself specifies and addresses the lack of clarity that the advocate was talking about. And you use the exact quotes from the section on the first point to show that, in fact, there isn't an absence of definition, that there are pretty clear definitions. And then you extend that by mentioning that the code, when it was passed, was specifically designed to address the three cases that the advocate mentioned as being the source of the problem. So in essence, the criteria that are being presented there are shown to address that particular problem. Now, you might have gone a little bit further by asking whether or not, for instance, the advocate provided any evidence that there's a harm from this, other than the speculation that there could be. So we've got hypothetical harm, but we don't have anything other than the three cases, which have already been addressed by the code change that's referred to here. Any additional risks are merely speculative at this particular point, and I think that that's something that you could have added to that argument. You mentioned three other cases that, for instance, seem to apply the code in a way that would address that, but all you do is you give us the names of the cases. You don't tell us how it addressed those particular issues. I think that would have clarified it a little bit more on the point, but you still are basically making the same argument here. And I was a little confused on your last point about the reasonable benefit service training, or the responsible benefit service training. It sounded like you said at first that California doesn't require this, and then maybe that's the source of the problem, that we don't require it, or that if we did require it, that there may be some issue with that. I was a little bit unclear about how that fits into the argument that you're presenting. So in essence, you could potentially be giving the advocate an out here and say, this is exactly the thing that we need to have, and we're not doing it. But like I said, it wasn't quite clear to me what was going on with that at the end. I understood what the program was. What I don't understand is how does it mitigate what the advocate's talking about, or how does it advance your particular position in contrast to what the advocate's talking about. That needed to be clear. All right, thank you.